As you don't need any introduction per se, but as the session protocol demands, so I'll just give your brief introduction to the students so that the students get acquainted with you a little more and they get to know about your profile a little more. So today, good afternoon, everyone, all the students and the other participants to the session. Today, we have with us this afternoon Mr. Ratan Singh. He is an advocate and arbitrator, and he heads the chambers of Ratan Singh. His areas of practice includes constitution and engineering law, and and arbitration at domestic as well as the international level. His areas of practice also includes mining law, commercial and civil litigation. He did his master's in geology and bachelor's in law from the Delhi University. He is the founder chairman of India branch of Society of Constitutional Law UK, as well as he is the director of the Indian branch of Chartered Institute of Arbitrators UK. He is a fellow of Chartered Institute of Arbitrators UK, and Mr. Singh is also a fellow of the Malaysian Institute of Arbitrators, apart from being a fellow of Asian Institute of Alternate Dispute Resolutions, headquartered at Kuala Lumpur. So this is a brief introduction to to Mr. Ratan Singh, and we extend a very warm welcome to you this afternoon, sir. And now the stage is all yours.
Thank you, Taruna. It was thank you for kind introduction, and I'm glad to be part of this ADR week-long ADR event. I'll be talking about a career in arbitration. As Taruna was saying, that kids, all law students would like to hear. Should they read arbitration? If so, why? What are career options? Is it really a field of law which gets you good amount of money, good amount of exposure, so on and so forth? Before we talk about arbitration, career in arbitration, couple of sentences about what is arbitration. I know that you have been hearing lots of eminent speakers on various aspects of arbitration. I'll just give very simple a definition of arbitration, though arbitration is not defined in any legislation, including in Indian legislation, in the Arbitration and Conciliation Act. So arbitration is a private consensual dispute resolution process before a private judge called arbitrator, who, by affording equal opportunity to the parties, decides the disputes in the form of award by following the procedure, which is either agreed by the parties or determined by the arbitrator, the private judge. I tried to cover basic aspects of the whole process of arbitration in this definition. I'll encourage all of you to try defining arbitration after every 3 months. And more you learn about the subject, more refined would be this definition of arbitration. So this is an interesting way to learn arbitration as a subject, arbitration as a concept, arbitration as a dispute resolution mechanism. So this is just an introduction of arbitration. In fact, why this introduction? Because arbitration is one-stop shop. Unlike litigation, where you can go in for appeal against the trial court judge's judgment or decree, You can go in for second appeal and so on and so forth. There's nothing called appeal against the decision of the arbitrator. Decision means award. There's no appeal. Yes, there is provision for objection on a very, very limited ground of violation of due process, or in other words, violation of principle of natural justice and violation of public policy. Again, very high threshold. Unlike appeals in courts against the court of lower court, against the appeal of the lower court, judgment of the lower court, there the appellate courts can go into all the facts, go into all the legal aspects. In arbitration, it doesn't happen. It doesn't work at all. The court, while deciding Section 34, is not supposed to go into all the facts and all the laws. Whether, even if there are erroneous findings of fact, there are erroneous findings of law, the court, while deciding objection against an award, cannot interfere with the award. And this is one thing you should keep in mind. That's why I said it is one-stop shop. If arbitration has failed for you, or if arbitration has failed, you have not been able to present your case properly as a lawyer or as a party, you had it. That's it. Nothing more. You have no option. There's no second chance. That's why it is said arbitration is as good as the arbitrator and all the stakeholders. Now, one question which comes in every law student's mind is how common is this whole process of arbitration? How popular is this arbitration? I must tell you, the estimation is in almost 70% commercial contracts, you have arbitration chosen by the parties as the process of dispute resolution. And in almost 100% international commercial contracts, parties choose arbitration as dispute resolution process. And if this is the statistics, can any lawyer afford to not know about arbitration? That is the question you have to ask yourself. Whether you want to be a lawyer, you want to be an in-house lawyer, you want to be a corporate lawyer, whatever, arbitration is not going to leave you. It will keep chasing you. So better you chase arbitration rather than arbitration chasing you. Now, recently I was giving a speech in a law college, and the moment I started, one boy got up and he says, "So, what kind of money one earns in this as arbitration professional if I want to become an arbitrator, or what kind of money one earns as the arbitration practitioner?" You have Schedule 4 attached to Arbitration and Conciliation Act, but there are very few arbitration happens under the Schedule 4. Schedule 4 arbitration happens when court appoints arbitrator with a clear direction that arbitrator will charge only the fee as per Schedule 4. Otherwise, arbitrators are free to decide their fees. As per Schedule 4, for one arbitration, arbitrator can get up to 49 lakhs of rupees. And what arbitrators generally do, and wherever they are not mandated by the court's order to follow Schedule 4, they decide their own fee. And what is the fee they decide? It starts with 1.5 lakhs for 2.5 hours, and which goes up to 5 lakhs for 2 hours and 2.5 hours per session. So per day, if you have sat for 2 sessions, that is 2.5 hours each pre-lunch and 2.5 hours post-lunch. So you double the number. So if you are charging 2 lakhs, so in 2 sessions you get 4 lakhs of rupees. This is typically how arbitrators charge. Apart from this, they charge reading fee. So it may be 5 lakhs of rupees, 10 lakhs of rupees, 20 lakhs of rupees, depending on the quantum of the work involved. So this is, in fact, and so far as lawyers are concerned, they charge huge amount of fee depending on their experience, qualification, and expertise in the process. So that again runs in crores, goes in crores, depending on what kind of experience you have and expertise you have. In fact, for arbitration, before I forget, for arbitration, clients will go to lawyers who know arbitration process, who are well versed in the arbitration processes and procedures. I'm talking about domestic, I'm talking about international arbitration. In fact, in one of the arbitrations, which is known as UCOS arbitration, it was an investment arbitration. Award value was 50 billion, and the claimant's counsel was paid 90 million USD, and respondent's counsel was paid 35 million USD. So if you really equip yourself in the manner those lawyers were paid, you can get paid that kind of money. Now, career options. What are the career options? You can become arbitration lawyer, arbitration counsel, or party representative. You can become arbitrator. You can sit as arbitrator. You can become in-house arbitration counsels. Increasingly, lots of large companies and infrastructure projects, or infrastructure companies, or engineering companies, oil and gas companies, or large multinationals are appointing in-house arbitration counsels. You can join arbitration institutions as case counsels. This is very sought after career option for young lawyers. You go to Singapore, you have SIAC there, Singapore International Arbitration Center. Invariably, you find good number of case counsels from India, from Indian law schools. You go to AIAC in Kuala Lumpur, headquartered in Kuala Lumpur. Earlier it was called KLRCA. Good number of new lawyers are there working as case counsels. This gives you very interesting learning, because you get to know how arbitrations are managed by arbitral institutions. You get to know about how institutional rules work when they are implemented by institutions. This gives you very, very interesting learning. Apart from this, you can also try to be tribunal secretaries. Internationally, the arbitration tribunals appoint tribunal secretaries who assist the tribunals in the conduct of the arbitration. In fact, HKIAC, that is Hong Kong International Arbitration Center, trains tribunal secretaries. You can apply for that, and then they will refer you cases. So you get to see, you get to work with top arbitrators. You can see them working in real time. You can see them, so you can learn from their experiences. This is amazing learning. This can be amazing learning experience. In fact, you can also become international bureaucrats, like lots of international institutions, like United Nations, the Commonwealth Secretariat, and organizations like them also appoint arbitration professionals. These are some of the career options you can look at. Now, next thing you need to know is what all to read in order to become a good arbitration professional. Obviously, as your teachers always suggest you, read the Bare Act. So read the Bare Act, that is Arbitration and Conciliation Act. Before I go to other reading material, I must say, arbitration is a global subject. Don't confine yourself to Arbitration and Conciliation Act of India. Various other countries and jurisdictions have their own legislations. Most of them are based on ancestral model law. Arbitration essentially makes you a global citizen. Arbitration teaches you how to think globally, how to have comparative analysis of the subjects you are dealing with. It teaches you very, very different kinds of skills. So never confine yourself to domestic arbitration. Don't think that who will get you international commercial law arbitrations, you don't know people and all. Don't have all of this in your mind. Create your infrastructure. Clients will come to you, cases will come to you. And even if you want to confine yourself to domestic arbitration, which you should never do, in order to do your domestic arbitration practice properly, you must be aware of international best practices. Because now we are in an era where there are no boundaries as such, legal boundaries for that matter. So you must be aware of international best practices if you want to be a good arbitration practitioner. So as I said, you should read Arbitration and Conciliation Act. You should read ancestral model law, which is the basis of your Arbitration and Conciliation Act 1996. United Nations wanted to have consistency amongst the trading countries, and this is how ancestral model law was brought in, and all member states were encouraged to follow the ancestral model law. And today, almost all trading nations in the world are following broadly, some with exactness, some with some difference, the ancestral model law. So if you read ancestral model law, you have virtually read and known about the legislations of hundreds of countries all across the globe. So read ancestral model law. In fact, before this 2015 amendment in Arbitration and Conciliation Act, our Arbitration and Conciliation Act 1996 was almost verbatim reproduction of ancestral model law. Even sections, numbers were the same, though we have some changes after 2015. So read ancestral model law And after that, read Travox or Travox Preparatories of Ancestral Model Law. That is, in other words, read legislative history of ancestral model law. I'll just give you an analogy. If you want to understand your constitution well, what you refer to as is called constitutional debate. So you get to know what was the intention behind having a particular article in the constitution. Similarly, if you want to understand your ancestral model law well, and in turn your Arbitration and Conciliation Act, you should read the legislative history of ancestral model law. This is freely available on Ancestral website. Go on Ancestral website and you get this. Now, on the Ancestral website, there is something called CLOUT, C-L-O-U-T, which is the digest of cases on various articles of model law or similar provisions in different jurisdictions. So it is basically digest of cases which have been decided in various model law jurisdictions. Model law jurisdictions means the countries and jurisdictions which are largely following ancestral model law. So you get to see how a particular provision of ancestral model law or their different variants in different jurisdictions have been understood and decided by courts in different jurisdictions. So that is one thing you can also have a look at. Now, as I said, if you want to understand a particular provision or a particular legislation, you should try to read the legislative history. Now, in 2015, Indian legislation in India brought lots of changes. Without going into the merit of those changes, those are legislations, and it has worked well. It has helped the whole regime in India quite well. Now, in order to understand these changes and amendments brought in Arbitration and Conciliation Act, what you should do is you should read the Law Commission's report, on the basis of which these amendments and changes were brought in our legislation in 2015. So that is Law Commission's report under the chairmanship of Justice A.P. Shah. You must read that. Very interesting read. After 2015 amendment, we have seen amendment in 2019. And again, substantive amendments, lots of amendments. And these amendments are largely on the recommendations of the report of Justice B.N. Sri Krishna Committee, a high-level committee under the chairmanship of Justice B.N. Sri Krishna, was constituted by Government of India. And that committee gave its report. This is one report everybody who has interest in arbitration or who wants to pursue arbitration as a career option must read. In fact, committee had requested me to give my views as well. So you'll find my name also mentioned in the committee's report. This report is a bulky report, but I'll encourage all of you to read this Justice B.N. Sri Krishna Committee's report. So, Arbitration and Conciliation Act, and then Ancestral Model Law, then CLOUT, Case Digest, and then Law Commission's report and Justice B.N. Sri Krishna Committee's report. Next is, you should read ancestral rules. This is different from ancestral model law. That was model law. This is called ancestral rules. What is this? What is this? Model law was the basis for arbitration legislations in all countries, or in the countries, the member countries. So it was a model law for domestic arbitration legislations. And UNCITRAL rules is essentially rules which tells you how to conduct ad hoc arbitration. In other words, you can say that UNCITRAL rules are essentially rules which has in it best practices of or for ad hoc arbitration. You must have read by now, ad hoc arbitration is different from institutional arbitration. Institutional arbitrations are those arbitrations where arbitration is administered, supervised by a particular institution chosen by the parties. Like in India, you have DIAC, Delhi International Arbitration Center, or MCIA in Mumbai, or ICADR. You still have ICADR. Then you have ICA, Indian Council of Arbitration. These are some of the domestic arbitration centers, which has got its own rules under which arbitrations are administered by these institutions. Internationally, you must know the popular international arbitration institutions. Most popular is ICC, Paris. You have, next comes LCIA, London Court of International Arbitration. In fact, SIAC is very popular, Singapore International Arbitration Center. You have HKIAC, Hong Kong International Arbitration Center. So there are many, like in USA, you have AAA, American Arbitration Associations, which governs domestic arbitrations, and AAA's arm, which conducts international arbitration, is called ICDR. So you should be aware of these arbitration institutions. You should follow these arbitration institutions. They keep conducting seminars, webinars, and so on and so forth, conferences. You should try to attend them, read their rules. So after I said UNCITRAL rules, next thing you should read is read the rules of one or two international arbitration institutions. So, for example, you should read ICC rules or SIAC rules. Read one of the two, or you read ICC alone. That's good enough. Today, most of the arbitration institutions have their rules, which are broadly similar to each other, though there will be some difference here and there, but that doesn't make much of a difference. So as I said, if you read UNCITRAL model law, you get to know broadly about legislations, arbitration legislations in lots of countries, because it is being followed in those countries. Similarly, if you read rules of ICC, for example, then you will get to understand rules of various other arbitration institutions, because those are largely on the same lines, with slight variations here and there. Just so what you should read is rules of any arbitration institution. Another thing which you can and which you should read, and I'll highly recommend this, and this is called broadly called soft laws. As I said, your arbitration legislation, like Arbitration and Conciliation Act, is an act which regulates the affair of arbitration in a particular jurisdiction. Like institutional rules, if you have agreed to be governed by the rules of a particular institution, then again it is binding on you, like your legislation. legislation of the seat of the arbitration. Now, there are something called protocols and guidelines which are not binding on the parties, but these are basically giving you the international best practices based on the contemporaneous practices being adopted by and practiced by topmost arbitrators, topmost arbitration lawyers, and topmost and other stakeholders. Please appreciate, arbitration is a process which is a confidential process. That's why in the definition I had said it's a private dispute resolution process. Now, you cannot barge in any arbitration hearing room and observe the proceeding. You cannot just get crash. These are confidential proceedings. So, therefore, you don't know how arbitration actually happens in real world. What are the challenges which are being faced by the arbitrators? What are the challenges which are being faced by the lawyers? How it is managed? There is nothing called civil procedure code for arbitration. Proceedings which happen in court are governed and regulated by civil procedure code. So if you read civil procedure code, you get to know the conduct of court litigation. But there is nothing called civil procedure code for arbitration or international commercial arbitration. So basically, based on the experiences of all the stakeholders, these protocols and guidelines are being prepared and updated from time to time. And therefore, I will highly recommend all of you to read these protocols and guidelines. Two very interesting, very relevant sources for this soft clause. One is IBA, International Bar Association, which has got very popular guidelines and protocols like IBA guidelines on taking of evidence. This is something all of you must read. It will tell you how in arbitration and in international arbitration, evidence is being led, how proceeding is conducted. And again, as I said, these are soft laws, not binding on the parties or on the arbitrator. But parties can, by agreement, agree to be bound by these soft laws. I have, in many arbitrations, seated in India, domestic arbitration, I have agreed, I have rather encouraged the other side lawyers to agree with me to be bound by IBA guidelines on taking of evidence. And if you are faced with experienced lawyers in arbitration, they will happily and readily agree to be bound by IBA guidelines on taking of evidence, even in domestic arbitration, because it gives you certainty. It brings certainty in the whole process. You know, this is how this whole evidentiary process, which includes under the IBA guidelines, discovery by way of production of documents, and so on and so forth, how it is to be conducted. So you have something to look at. It gives you predictability. It gives you certainty in the whole process. This is amazing. And the statistics suggest that almost 70% international commercial arbitration these days, the parties agree or the arbitrators decide that this particular arbitration proceeding will be conducted under IBA guidelines on taking of evidence. I have represented parties in international arbitration seated in London or Singapore or Japan, where we agreed with other side, or the tribunal decided that arbitration will be conducted under the rules of IBA guidelines of taking of evidence. So this is similarly, they have got something called IBA on conflict of interest. If you see your Schedule 5 and Schedule 7 of your Arbitration and Conciliation Act, which was brought in 2015 through 2015 amendment, this is nothing but almost reproduction of IBA guidelines on IBA rules on conflict of interest. So you can imagine the value of such guidelines. You have one international organization, non-governmental organization, came out with a particular rule which was adopted by legislature in India and made a part of the legislation. So this is very, very interesting read you can have. Similarly, there are other guidelines and protocols of IBA. Another very good source is Chartered Institute of Arbitrators UK. You should also go to the website of Chartered Institute of Arbitrators UK, crb.org.uk or something. Go on that website, and it has got guidelines and protocols on almost all relevant aspects of arbitration. How to write award, how to deal with the cost, how to deal with interest, how to conduct proceedings, so on and so forth. So basically, these are freely available resources which are very, very important. You must take out time to read these guidelines and protocols. Now, on the books, there are 3 books I would suggest you can buy either of the 3. One is book written by Gary B. Bourne, published by Kluwer. That is one. It has got a student edition as well. That is paper book edition. And one is reference book, which runs into 3 volumes, which have just been published. 3rd edition has just been published. So that is one book by Gary B. Bourne. Second is Ratan Hunter. That's again paperback student edition. Ratan Hunter, very popular book, and particularly in UK and Middle East, Far East. This book is very widely read by law students in law colleges. And third book, which is again very, very good book, I must say, and which is widely read in US law colleges, is by Margaret L. Moses. It is again Cambridge University Press publication. So one of the 3. And I would now say, if you want to become a good arbitration professional, good arbitration lawyer, become a good litigator. Some may laugh at it, but this is how it works. This is how it should work. Good litigator makes good arbitrator, provided you pursue arbitration alongside your litigation practice. Start your career after your law school with a litigator, hardcore litigator, who does trial work, who practice law of evidence, civil procedure code, who conducts cross-examinations, and pursue arbitration simultaneously. This is what I did when I started my career, and I continue to do the same. Most of the arbitrators in India are retired judges of Supreme Court and High Courts. Most of the lawyers who are practicing arbitration are essentially litigators. You cannot represent your parties well if you do not understand their language, and you cannot answer them in their language. They think in terms of CPC, they think in terms of Indian Evidence Act. Yes, Arbitration and Conciliation Act says that CPC doesn't apply, Evidence Act doesn't apply. But you must know what doesn't apply. For that, you need to know what CPC is and what Evidence Act is. Therefore, good litigator makes a good arbitration lawyer, and good arbitration lawyer makes a good litigator. It's vice versa. If you are practicing your arbitration well, you get to know the best practices of arbitration, like discovery, which is not very common in court litigation, but which is very common in big arbitration and international commercial arbitration. Rather, costliest stage of any arbitration is discovery by way of production of documents. Now, if you have involved yourself in a couple of good arbitrations and have been involved in good discovery processes, you would understand the importance of this process, for which you have provision in CPC as well. But people hardly use this tool of fact finding, which can be amazing tool for defending your client or representing your client. So therefore, I would say pursue litigation and pursue arbitration simultaneously. Don't think that if I have to pursue the arbitration, I should not know what litigation is. I should not know what CPC is. I should not know what Evidence Act is. This is where lots of people commit mistakes. Don't do this. One question which is asked by law students, whether LLM helps. LLM does help. LLM helps. My suggestion personally is, after your LLB, have 1 or 2 years experience in court, get to know this real world, then go for LLM. It helps you better. Dual qualification, this is another question which comes very often. Dual qualification works and works for international commercial law, international commercial arbitration. You should, I tell you, small things help you so much. If you are traveling domestically or internationally, try to visit the arbitration institutions. Try to visit their libraries. Now, obviously, arbitrations you cannot observe until unless it is treaty arbitration or exit arbitration. Like I was, 2014, I had gone to speak in Harvard. And while coming back, I had a meeting with exit Secretary General McKinney in DC. So exit is, though India is not a party to this convention, so it is headquartered in World Bank building. So there, she took me to one proceeding which was going on. It was international investment treaty arbitration, exit arbitration, which was open to public, so you could see them. So this is something I thought I must bring to the notice. Another thing is start your career at the earliest. There are some arbitration institutions, and forget about some arbitration institution. There is one arbitration institution whose accreditation is globally recognized, and even students can get that accreditation, and this is called Chartered Institute of Arbitrators UK. Chartered Institute of Arbitrators UK conducts accreditation programs, and it has got 3 tier of accreditations. First level is associate level, second level, next level is member level, and third is fellowship level. And if you are fellow of Chartered Institute of Arbitrators, nobody in the world will ever ask you how much you know about arbitration, because that accreditation itself is complete introduction of yours. And if you have got first level accreditation, you can write after your name a suffix ACIARB. If you have got member level accreditation, you can write after your name MCIARB. And if you have got fellow level accreditation, you can write after your name FCIARB. This is amazing suffix to have. And I can tell you from my personal experience, I am their fellow for a long number of years. I am their director in India for last 13 years. I am their internationally recognized tutor, and I teach for all the levels of accreditation. This is amazing accreditation. It is a learning process. It doesn't come with subscription only. It doesn't come with subscription. It comes with knowledge, expertise. So this is amazing path to take, and they also give membership to students, law students. So you must try for that student membership to start with, and then you can go to further levels of associate to fellowship. That is one thing you must do. Start, and you should also try to become member of other arbitration institutions. Lots of other arbitration institutions are providing young membership, student membership. You should go for that. One blog I would say you must read is Kluwer blog, which comes for free. You just have to get registered yourself for that. It's Kluwer's blog. Very interesting articles keep coming. It comes for free. Participate in moot courts, and if you get to participate in Wish, Vienna, or this Hong Kong East, amazing learning process. Amazing learning process. I have judged these moot courts. I have been coach of these teams. This is amazing learning process for law students. If you don't get chance to be part of this moot team, try to be part of other teams of. There are some arbitration moot courts which are conducted in India. So we do that. This is very, very good learning experience. Try to develop your skills, writing skills, I would say, writing skills. Work on your, improve your English as much as you can. You should be in a position to play with words. It helps you immensely. Writing skills helps you immensely. Write blogs, write articles, contribute for law journals, contribute for law reports. These are some of the interesting aspects which you must be aware of. And what happens is, once you know CPC, once you know Evidence Act, thereafter at later stage or while doing arbitration, you can then unlearn those CPC and Evidence Act when you are wearing the hat of an arbitration professional. These are some of my thoughts on career in arbitration. My time is up. I must thank all of you for being part of this process. And try to pursue this career, which is amazing career. Sky is limit. Sky is the limit. This can give you everything. Everything means everything. Thank you very much.
Thank you so much, sir. It was a pleasure to hear you. I would now invite all the students to have, direct questions to sir. We still have another, if sir permits, we still have another 5 minutes to ask if you have any questions.
Hello.
Karan Shah, did you have any questions? 17 BBL 017. If you're unable to speak, you can also put it in the chat box.
No, ma'am.
Okay.
Hello. Am I audible? So good evening, sir. Sir, my question is that you have mentioned that the arbitration proceedings are private. So, how far they are private? Like the proceedings or the award is also private? Because as we have seen that there are some very news about the arbitration proceedings that this party has won this arbitration for this much amount. So whether they are only private proceedings or the award is also private.
Whole process is private and award is also private, so long as it is not challenged in court of law. Once it is challenged in court of law, whole record goes to court of law and then it becomes public. Though there are jurisdictions, unlike in India, countries like Singapore, there even in courts, they mask the identity of the parties. They conduct the whole proceeding in such a manner that identity of the parties and the trade secrets are not made, or other commercials are not known to the public at large. Yes. Any other question?
Does anyone else have any question?
Yes, ma'am. Can I?
Yes, please go ahead.
Good evening, sir. Sir, can you please highlight the scope of arbitration litigation?
Arbitration litigation is essentially proceeding which happens in court of law after arbitration gets over, or when during pendency of the arbitration proceeding, under some of the situations which are emphasized under Arbitration and Conciliation Act, one goes to court and court intervenes. And this is where again your knowledge of CPC evidence and court litigation helps you. So it's always good to be a mix of a good litigator and good arbitration professional. Yes.
I think with this we come to the end of the session. If nobody has any more questions. Thank you so much, sir. So Shalini, our student coordinator, is going to be expressing the word of thanks. Thank you. Over to you, Shalini.
A very good morning, one and all. To begin with, I would like to extend my heartfelt gratitude to Mr. Ratan Singh for providing us with his insights into career options available in arbitration. It is indeed an honor and privilege for us to hear from someone who has dedicated most of his legal career to arbitration. Thank you, sir, for providing us with an enriching and valuable insight into this area when we are at a stage in our student life where we have to make decisions regarding the field we want to work in the future. We are extremely grateful to you, sir, for giving us some of your valuable time. Thank you, sir. I would also like to thank our Dean and Director, Professor Dr. Purvi Pokharial, for giving us all the opportunity to be a part of such enlightening session. I would also like to extend my gratitude to the faculty coordinator for this event, Professor Nikita Koradia ma'am and Professor Taruna Jhakar ma'am, for ensuring all the modalities for the event. At last, I would like to thank all the participants for being active and patient audience. Thank you, everyone.
Thank you.
Thank you so much, sir. Thank you. Have a very good day.
Thank you. Thank you. Thank you.